This presentation is focused on two key elements of contractual formation, that of offer and acceptance. The law of contract is about the enforcement of promises. Not all promises are enforced by courts. To enforce a set of promises or an agreement, courts look for the presence of certain elements. When these elements are present, a court will find that the agreement is a contract. This is a somewhat artificial process, however. To a certain extent, courts will find that some agreements simply look like contracts, and then they reason backwards in order to find the elements necessary to form a contract. To say that we have a contract means that the parties have voluntarily assumed liabilities with regard to each other. The process of agreement begins with an offer. For a contract to be formed, this offer must be unconditionally accepted. The law imposes various requirements as to the communication of the offer and the acceptance. Once there has been a valid communication of the acceptance, the law requires that certain other elements, that we will talk about later, are present. If these elements are not present, a court will not find that a contract exists between the parties. In the absence of a contract, neither party will be bound to the tentative promises or agreements they have made. It is thus of critical importance to determine whether or not a contract has been formed. It is important to understand that it is not the subjective intentions of the parties that determine the legal effect of their words or actions, but how these seem to an external observer. This means that the offer is interpreted according to an objective intention, the interpretation the reasonable person in the position of the offeree would place upon the statement or action of the offeror. This is crucial in answering the basic question, what is an offer? An offer, therefore, is an expression of willingness to contract on certain terms. It must be made with the intention that it will become binding upon acceptance. There must be no further negotiations or discussions required for an offer to be valid. It is very important to realize from the outset that not all communications will be offers. They will lack the requisite intention to be bound upon acceptance. If they are not offers, what are they? At this point, we will distinguish an offer from the other steps in the negotiation process. Other steps in the negotiation process might include a statement of intention, a supply of information, or an invitation to treat. Let's have a look at those in turn. A statement of intention means that if one party states that he intends to do something, this is something different from an offer. In an offer, somebody is stating that they will do something. A supply of information suggests the following. If one party provides information to another party, he supplies the information to enlighten the other party. The statement is not intended to be acted on. An invitation to treat. An invitation to treat is an indication of a willingness to conduct business. It is an invitation to make an offer or to commence negotiations. Courts have considered whether or not a communication was an offer or an invitation to treat in a wide variety of circumstances. A display of goods in a shop, for instance, is generally an invitation to treat, and so is an advertisement or the request for a tender. An auctioneer's request for bids is also an invitation to treat, which means that the bid is an offer. This happens when the auctioneer brings his hammer down and then he has accepted the offer. To be effective, an offer needs to be communicated in the sense that the offeree, the person who will accept, knows of the existence of the offer. There can be no acceptance of the offer without the knowledge of the offer. The reason for this requirement is that if we say that a contract is an agreed bargain, there can be no agreement without knowledge. There can be no meeting of the minds, if you wish, if one mind is unaware of the other. Stated another way, an acceptance cannot mirror an offer if the acceptance is made in ignorance of the offer. The authorities here, however, are rather divided on the need to communicate the offer. For a contract to be formed, there must be acceptance of the offer. The acceptance must be an agreement to each of the terms of the offer. It is sometimes said that the acceptance must be a mirror image of that offer. The acceptance can be by words or by conduct, and it occurs when the offeree's words or conduct give rise to the objective inference that the offeree assents to the offeror's terms. If an offeree attempts to add new terms when accepting, this is a counter-offer and not an acceptance. A counteroffer implies a rejection of the original offer, which is thereby destroyed and cannot be subsequently accepted. Where the offeree queries the offer and seeks more information, this is neither an acceptance nor a rejection of the original offer, so the original offer stands. In some cases, the parties will attempt to contract on different standard forms. In this instance, there will be a battle of the forms, with offers and counter-offers passing to and fro. The Court of Appeal has held that the last shot wins this battle of the forms. The general rule is that acceptance is not effective until it's communicated to the offeror. This is sometimes expressed by saying that the acceptance cannot be made through silence. The offeror cannot waive communication if that would be to the detriment of the offeree. The general rule is displaced in the case of a unilateral contract. A unilateral contract is one where one party makes an offer to pay another if that other party performs some act or refrains from some action. The other party need make no promise to do the act or refrain from it. In these cases, acceptance of the offer occurs through performance, and there is no need to communicate acceptance in advance of this performance. An example of the offer of a unilateral contract is an offer of a reward for the return of, say, a lost cat or a dog. In the case of Carlyle versus Carbolic Smoke Ball from 1893, it was established that performance is the acceptance of the offer and there is no need to communicate the attempt to perform. Communication of the acceptance is waived because it would be unreasonable of the offeror to rely on the absence of communication, which would have been superfluous or which no reasonable person would expect to be made. The general rule is that for an acceptance to be valid, it must be communicated to the offeror. It must be brought to the offeror's attention. To this general rule, there are certain exceptions, situations where the law does not require communication of the acceptance, such as unilateral contracts. The other principal exception is the postal acceptance rule. Communication by post gives rise to special practical difficulties. If an offer is posted, the offeree receives the offer and posts her acceptance. The letter of acceptance will take several days to arrive, at which point is the acceptance then good? If one waits until the offeror receives the letter, how will the offeree know that this has happened? The offeree has known from the time she posted the letter that she has accepted the offer. There is also the occasional problem of the letter, that the letter might never arrive at its destination. To overcome these problems, the courts have devised an exception to the general requirement of communication. The exception was devised in the cases of Adams and Linsell and household fire insurance. These decisions established the postal acceptance rule. That means that the acceptance is complete when posted. This puts the risk of delay and loss on the offeror. It is important to understand that the rule is an exception to the general rule requiring communication. The postal acceptance rule will only prevail in certain circumstances. It will prevail where use of the post was reasonably contemplated by the parties or stipulated by the offeror. The operation of the postal acceptance rule creates practical difficulties, however. The greatest problem is that contracts can be formed without the offeror being aware of the contract. Partly because of these problems and partly because of technological advances, the post is admittedly not a very crucial method of communication anymore, the courts seem to be confirming the scope and confining the scope of the postal acceptance rule. As modern forms of communication such as fax and email have become almost instantaneous, courts have shown a marked reluctance to extend the postal acceptance rule to these new forms of communication. English contract law awaits a case involving an almost instantaneous communication such as fax or email. It is clear that the contract can be formed through such mediums. There can, therefore, be two possible approaches to email communication of the acceptance, either the postal analogy or the receipt rule. Sometimes an offeror may stipulate that acceptance is to be made using a specific method. In other cases, the required method for communicating acceptance may also be inferred from the making of the offer. The problem that arises is this: if the offeree uses another method of acceptance, does this acceptance create a contract? The answer is that if the other method used is no less advantageous to the offeror, the acceptance is good and a contract is formed. This is the result unless the offeror stipulates a certain method of acceptance and further stipulates that only this method of acceptance is good. It's also important to note that offers do not exist indefinitely. They're not open for an indeterminate time. They could be, but some offers may not indeed be accepted. There is no legal requirement, therefore, that a contract has been concluded. It's important to note that offers do not exist indefinitely. They can be open for an indeterminate period awaiting acceptance, but some offers may never be accepted. There is no legal commitment, therefore, until a contract has been concluded by the acceptance of an offer. Because there is no legal commitment until the contract has been formed, either party can change their mind or withdraw from negotiations. In situations where an offeror has stipulated that the offer will be open for a certain period of time, he or she can nevertheless withdraw the offer within this time period. This is called revocation. This will not be the case, however, where the offeror is obliged by a separate binding collateral contract to keep the offer open for a specified period of time. For the revocation of an offer to be effective, there must be actual communication of the revocation. It is not necessary for revocation to be communicated by the offeror. Communication to the offeree through a reliable source is sufficient. If an offeree rejects an offer, the offer is at an end, as would be the case if the offeree makes a counteroffer. Different problems arise, however, when it is the offeree who changes his mind. For example, if after posting a letter of acceptance the offeree informs the offeror by telephone, before the letter arrives, that they've rejected the offer, should the act of posting an acceptance prevail over the information actually conveyed to the offeror? In the absence of a definitive answer in the case law, the question must therefore be answered primarily as a matter of principle. Treitel suggests that the issue is whether the offeror will be unjustly prejudiced by allowing the offeree to rely on the subsequent revocation. Where the offer is made subject to a condition which is not fulfilled, the offer also terminates. The condition can in fact be implied. The death of an offeree normally terminates the offer in that the offeree's personal representatives could not purport to accept the offer. The offeror may also set a time limit for acceptance. Once this limit has passed, the offer lapses. In many cases, the offeror can revoke the offer before the time period lapses, provided that the offer has not been accepted. In cases in which no time period is stipulated for the offer, an offeree cannot make an offeror wait forever. The offeror is entitled to assume that acceptance will be made within a reasonable period of time or not at all. What a reasonable period of time is, of course, depends upon the circumstances of the case.